This was all filed back in 2024. The court will note that there is this motion that also involves, looks like there was a change of custody or change of status circumstance in Williamson County back in 2014 after the original order in this matter in 2012 set up custody, visitation, and child support with Miss Powers being the custodial party, and it appears that CPS intervened, removed the children from her, and placed them with the father. Unfortunately, didn't transfer the Bell County case down to Williamson County, and so yeah, so now we're coming back and dealing with it because it appears that based on the pleadings that Mr. Garcia has had these children for the last 10 years. So, and there's a motion to a lawsuit to regain, to have funds returned. Hopefully the
The
state's
court
holding.
began by reviewing a complicated family case that originally started years earlier. The judge explained that the first custody and child support order had been issued back in 2012. At that time, the children's mother, Miss Powers, had been named the custodial parent, while the father, Mr. Garcia, was ordered to pay child support and provide medical coverage. However, the situation changed dramatically not long after that order. In 2014, Child Protective Services stepped in and removed the children from the mother's care. The children were then placed with their father. Unfortunately, even though the custody situation changed, the legal paperwork and child support case were never properly transferred between counties. Because of that mistake, the court system continued to treat the case as if nothing had changed. According to the filings presented in court, Mr. Garcia had actually been raising the children for nearly 10 years. The judge pointed out that the court now had to untangle this long-standing legal confusion. The case being heard today involved a request to correct the situation and potentially return funds that had been collected over the years.
Some that we can get to today, but anyway, the court will know for the record that Ms. Powers is not present, that Ms. Lopez, his counsel, is present, Mr. Garcia is present, and the state is present. So at this time, I'll ask the state for an opening to tell the court what the state's requesting we do here today. And then, Ms. Lopez, I'll allow you to make an opening statement on behalf of your client. I understand you're only representing him on the claim to try to get the funds back, but not anything else dealing with custody, visitation, and child support in this matter going forward. So at this time, Mr. Welch, I'll start with you, and then I'll go to Ms. Lopez. Thank you.
Thank you, Your Honor. So the state and Ms. Lopez and her client have come to a temporary agreement regarding our pleadings. We agree to stop Mr. Garcia's support effective February 28th, 2014. And we also agree that his child support arrears and medical support arrears should be set to zero. Due to possession credits, Your Honor, we don't have the exact calculation for the possession credits. We will add that onto the temporary order or final order. But we do agree that there is substantial enough that they would reduce it down to zero. And the state will have two exhibits to offer when evidence comes: an affidavit from Mr. Garcia that states he's had both children since March 4th, 2014, and then also a financial activity report, so we can get that into evidence now. And we would then request a special setting to resolve the other issues. We are working on serving Miss Powers with our change of status notice. We haven't done it yet, but we have good hope that we're going to get it done. And that's about it, Your Honor.
All right, Ms. Lopez.
Yes, Your Honor, thank you. As the court mentioned, I am here on a limited scope notice, and I appreciate the court acknowledging that. This motion concerns two children, Celeste Garcia and Noah Garcia. Most of the information I think that has been shared this morning is on point. There's one small caveat in that in the Williamson County CPS litigation, paternity testing was done for Noah Garcia.
The judge officially noted who was present in the courtroom. Mr. Garcia was there with his attorney, Ms. Lopez, while the state's representative was also present to explain the government's position. The judge clarified that the children's mother, Ms. Powers, was not in attendance for this hearing. Before proceeding further, the judge invited the state's attorney to explain what the government was requesting from the court. The state explained that discussions had already taken place between their office and Mr. Garcia's legal team. As a result of those conversations, they had reached a temporary agreement regarding the child support issues. The state proposed that Mr. Garcia's child support obligation should officially stop as of February 28, 2014. They also recommended that both child support and medical support be reduced to zero because Mr. Garcia had been caring for the children during that time. The state admitted they still needed to calculate the exact credit for the years he had physical custody. However, they believed those credits would completely eliminate any support balance. To support their request, the state planned to submit evidence showing that Mr. Garcia had been the primary caregiver since 2014.
And it was determined that Mr. Garcia, my client, is not the biological father of that child. And so what the Williamson County Court then did was they found the other potential father to be the legal father of this child. And so Noah is no longer a part of Mr. Garcia's life. Celeste, on the other hand, his daughter, also came to live with him around the time that the CPS litigation was going on. So we have two different things that occurred with each of these kiddos, but one would essentially should have terminated the support because my client is no longer considered the legal father of that child. And then the other, he's had possession of her since I think the agreement is around March 1st, 2014. So we are asking the court today, as the Attorney General suggested, that you abate or stop my client's child support obligations as of February 28th, 2014, that we return any funds that the OAG is holding to him, and that we also agree that the arrears go to zero at this point. And so that's what we're asking of the court today.
All right, and that's an agreement between the state and Mr. Lopez and Ms. Lopez and Mr. Garcia. Is that correct, Mr. Welch?
Correct, Your Honor. I'm not sure if the return of our held funds to him should be in the order itself, but we will. We do plan on returning them. But yes.
Okay. All right, then. And when you're looking at doing a final on this one, folks, because you said I was looking for the citation.
Ms. Lopez then addressed the court on behalf of Mr. Garcia. She explained that she was representing him only for the financial portion of the case and not for any future custody disputes. According to her statement, the case involved two children, Celeste Garcia and Noah Garcia. She confirmed that most of the information shared by the state was accurate, but said there was one important detail the court needed to understand. During the CPS case in Williamson County years earlier, a paternity test had been performed for Noah. That test revealed that Mr. Garcia was not actually Noah's biological father. After that discovery, the court determined that another man was the child's legal father. Because of that ruling, Noah was no longer legally connected to Mr. Garcia. As a result, Mr. Garcia should not have been responsible for paying support for that child after the DNA results were confirmed. Ms. Lopez explained that Celeste's situation was different. She had come to live with Mr. Garcia around the same time as the CPS investigation and had remained in his care ever since.
Mom, and I didn't find it, so I was wondering about that. So, I totally missed the finding of non-parentage on Noah. So yeah, so again, this one definitely is a little complicated. So at this time, I'll go ahead and we'll go ahead and set this up for a final hearing. And what date are you going to look at trying to do that for? And I'll go ahead and see about granting the order. If you want to get some testimony from Mr. Garcia, we'll go ahead and get that done. All right. So at this time, I'll go ahead and swear Mr. Garcia in. I'll let y'all both call as witnesses, and then we'll figure out when we're going to get this matter reset up and confirm the information based on his testimony. So at this time, Mr. Garcia, raise your right hand, sir. Sir, do you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and that but truth will help you?
Yes, sir.
All right, thank you very much. All right, you put your hand down, sir, and I'll let the lawyers call you as needed. All right. So at this time, Ms. Lopez, you wish to call your client, or Mr. Welch, you want to go ahead and call him at this point?
Your Honor, I think best for Ms. Lopez to call her client, and then I can cross.
No problem. All right, then, Ms. Lopez, you can call your client as a witness. Thank you.
Yes, Your Honor, I'll keep it brief as possible. Mr. Garcia, please state and spell your full name.
It's Pedro Garcia, Pedrogarcia.
And thank you. And you were previously in a relationship with a respondent, Ms. Brittany Powers, correct?
Yes, ma'am.
Okay. And when did that relationship begin approximately?
It was in 2009.
Okay. And when did your relationship with Ms. Powers end?
It was 2014.
Okay. And during that time, Ms. Powers gave birth to 2 children, correct?
Yes, ma'am.
Okay. And would you please provide me with the full name and birth date for each of those children?
There's Noah Isaiah Garcia. His birthday is March 5th, 2010. And Celeste Isabel Garcia, her birthday is August 30th of 2011.
Thank you. And at some point after your relationship with Ms. Powers ended, were custody and support orders entered for those children?
Yes.
Okay. And that was here in Bell County, is that correct?
Yes.
Okay. And per the court's order, you and Ms. Powers were named joint managing conservators of those children. Is that correct?
Yes, ma'am.
And Ms. Powers was established as the joint conservator who had the exclusive right to designate the children's primary.
Ms. Lopez asked the judge to take several actions based on these facts. First, she requested that the court officially stop Mr. Garcia's child support obligation dating back to February 2014. She also asked that any funds currently being held by the state's child support office be returned to him. In addition, she requested that any child support balance be reduced to 0 since Mr. Garcia had already been raising his daughter during that entire period. The state's attorney confirmed that they generally agreed with this request, although they would need to finalize the financial calculations. The judge acknowledged that the case was unusually complicated because of the different court orders issued in separate counties over the years. Because of that complexity, the judge decided to schedule a final hearing at a later date to resolve all remaining issues. However, before doing that, the judge wanted to hear testimony directly from Mr. Garcia to confirm the details of the situation.
Resident.
Yes.
And you were required to pay some child support totaling $271 a month starting December 1st, 2012.
Yes.
And you were also, and Ms. Powers, excuse me, was ordered to enroll the children in a government health plan. Is that correct?
Yes.
Okay. And then were you also required as a part of that Bell County order to pay $57 a month in cash medical support starting in December 1 of 2012?
Yes.
Okay. And at some point, Celeste came to live with you. Is that correct?
Yes, ma'am.
Okay. And when was it that Celeste came to live with you, Mr. Garcia?
It was she was off and on from like 2012 to 14, but I had her the majority of the time. It wasn't until March of 2014 whenever I had her full time.
Okay. And how old was she in March of 2014 when she came to live with you?
She was 3 years old.
Okay. And is she currently enrolled in school?
Yes, ma'am.
And what grade is she in?
She's in 8th grade.
And have you registered school Celeste for school every year since she first began?
Yes, ma'am.
Okay. What periods of possession has Ms. Powers exercised since Celeste came to live with you, if any?
There's none.
None. Okay. After Celeste came to live with you, was there ever another order signed by the court that stopped your child support obligation?
No.
Okay. And Noah stayed in Ms. Powers' primary care originally, is that correct?
Yes.
Okay. And
Mr. Garcia was then sworn in as a witness and asked to raise his right hand to promise that he would tell the truth. After taking the oath, Ms. Lopez began questioning her client. She first asked him to state his full name for the record. Mr. Garcia confirmed his name and explained that he had previously been in a relationship with the children's mother, Brittany Powers. He told the court that their relationship began around 2009 and ended in 2014. During their time together, Miss Powers gave birth to 2 children. Mr. Garcia listed their names and birth dates for the court: Noah Isaiah Garcia, born in March 2010, and Celeste Isabel Garcia, born in August 2011. The attorney then asked about the court orders that had been issued during their relationship. Mr. Garcia confirmed that in 2012 the Bell County Court had issued an order naming both parents as joint managing conservators. However, Miss Powers had been granted the right to decide where the children lived, and Mr. Garcia had been ordered to pay child support each month.
did she subsequently lose custody to Noah to the Department of Family and Protective Services?
Yes.
And when did that CPS lawsuit first begin, Mr. Garcia?
Started in September of 2014
And what county was that lawsuit filed in?
in Williamson County.
Okay. Importantly, Celeste was not named as a child or in that lawsuit, correct?
No, she wasn't.
Okay. And during the course of the CPS litigation, was there a question about whether or not you were Noah's biological father?
Yes.
Okay. And did the other potential fathers submit to DNA testing as a result of that question?
Yes, he did.
And what were the results of that testing, Mr. Garcia?
He was the father, and I signed my rights over to him.
Okay. And did the Williamson County Court subsequently find Mr. Mendoza to be Noah's biological father?
Yes.
And Mr. Mendoza is the other potential father, correct?
Yes.
Okay. Now, of course, the legal father. After that order in Williamson County was entered, did the Bell County child support obligation change related to Noah?
Yes, it did.
Were you still required to pay child support for him, Mr. Garcia?
Enough for Noah, just only for Celeste after that.
And have you made payments toward the 2012, have you made payments towards those child support obligations that were established in 2012?
Mr. Garcia explained that under the 2012 court order, he was required to pay $271 per month in child support. He also had to enroll the children in a government health program and pay additional cash medical support each month. When asked what happened later, Mr. Garcia told the court that his daughter, Celeste, eventually came to live with him. He said that between 2012 and 2014, she stayed with him frequently, but by March 2014, she was living with him full-time. At that time, she was only 3 years old. Since then, he had been responsible for raising her and had enrolled her in school every year. When asked about the mother's involvement during that time, Mr. Garcia told the court that Miss Powers had not exercised any visitation. According to his testimony, she had not spent time with Celeste since the child began living with him permanently. Despite this major change in custody, the child support order had never been officially updated.
Yes.
Okay. And are you asking the court today to terminate your child support obligations as to both children as of February 28th, 2014, per the tentative agreement with the Attorney General?
Yes, ma'am.
And are you further asking this court to enter an order that requires the Attorney General or State Disbursement Unit to return any of the funds that they have held in your account at this time?
Yes.
Okay, I pass the witness.
All right, Mr. Welch, your witness.
Thank you, Your Honor. So, first of all, state offers would have been marked as State's Exhibit A.
No objections.
All right, States A is the affidavit of possession, and it is admitted. Thank you.
And then the state offers was marked as Exhibit B, the financial history report.
Also no objection.
All right, States B is also admitted. All right, Mr. Welch, any questions of the witness? Any questions of the witness, sir?
No, Your Honor.
All right, so folks, I'm looking at going ahead and we're setting this up as a temp. Is that correct?
Yes, Your Honor.
And because again, we got to look at getting mom served and everything else. But for right now, based on the information and everything that the court has heard, I'm gonna find this in the child's best interest and in accordance with law that we go ahead and stop any and all child support obligations that should have been stopped a long time ago from the father to the mother. Take that, reduce give him a judgment of 0 going forward. And I'll go ahead and sign off on any agreed to order trying to return the funds that are owed for him at this time and reset this matter to make a final order once we get mom served, or if the state, if somebody's going to do some type of substituted service on her or appointment of it ad litem or whatever y'all need to do to get this taken care of. Because does anyone actually know who this lady is at this point?
Yes, Your Honor. So I'm sorry, we were able to have her served. Mr. Garcia provided 2 addresses to us where she potentially stays. We were able to locate her at one. I am happy. I was just asked this morning to provide that information to the OAG. And with my client's conversation here in a moment, I was in permission. I was going to, of course, do that so we could hopefully get her served.
Okay, all right then, and obviously give her 45 days notice and all that other stuff. This is going to take a little while still, but we'll get it taken care of. Is there anything else at this time that the state is requesting? Or
The questioning then shifted to the situation involving Noah. Mr. Garcia explained that Noah originally stayed in his mother's care after the relationship ended. However, she later lost custody of Noah when the Department of Family and Protective Services became involved. The CPS case began in September 2014 in Williamson County. During that investigation, questions arose about Noah's biological father. Another man was identified as a possible parent, and the court ordered DNA testing to determine the truth. Mr. Garcia confirmed that the test results showed the other man was the biological father. After that discovery, Mr. Garcia signed documents giving up his parental rights so the biological father could legally take responsibility for the child. The Williamson County Court later issued an official ruling confirming that the other man was Noah's legal father. From that point forward, Mr. Garcia was no longer responsible for supporting Noah.
at this time, Mr. Welch?
So just to make sure, Your Honor, you're stopping the child support and medical support obligations as of that February 28, 2014.
Correct.
And then you're going to reduce down to 0 the child support and medical support arrears.
Correct.
And like I said, Your Honor, we'll the state will provide exact calculations when it comes to possession credits and stuff, either in the temp order or in the final. And we can work out whatever language for the return of the held funds.
Okay. All right then. Let's get this gentleman his money back. He's been raising this little girl for the last 10 years, going on 11. So yeah, she's in 8th grade now. It's time. It's definitely time to move on. Is there anything else, Mr. Welch?
Your Honor, I would ask for us to set up a special setting, like maybe 2-3 months out, or maybe 2 months out, so that we have it there.
At this time, Mr. Welch, you really remember the judge is looking at surgery, joint replacement, the surgery, and I'll know more about that in a month. I'll go ahead and I'll go ahead and give y'all a date, but I'll probably need to do it at least 90 days out, 90 days plus out, sometime this summer, and that way I know I'll be back by then. Or better yet, Ken Law can still probably do this one, if he's on the bench. All right, so But I can go. Yeah, that shouldn't be a problem with that. So I'll just go ahead and look at something about 90 days out, and Mr. Lopez, I'll let you see what your schedule looks like. But it may not be me. It may be Judge Law. But
After hearing this testimony, the state introduced two pieces of evidence into the record. The first document was an affidavit from Mr. Garcia stating that he had been raising the children since March 2014. The second document was a financial report related to the child support account. Mr. Garcia's attorney did not object to either document, so the judge accepted both as evidence. Once the paperwork was admitted, the judge reviewed the information and explained his temporary decision. Based on the testimony and the evidence, the judge stated that it was clearly in the child's best interest to correct the outdated child support order. He ruled that Mr. Garcia's child support obligations should have been stopped many years earlier when the custody situation changed. The judge said he would temporarily stop all support payments and reduce the outstanding balance to zero while the court worked toward a final order. He also indicated that the court intended to return any funds that were currently being held for Mr. Garcia.
it's simple enough. He's been, I think the former Chief Justice of the Third Court of Appeals can get things right every now and then. So yeah. So here we go. Look at my. I know I don't have anything that far out. Okay. Belinda's telling me May 27th. I got nothing at 9:30 in the morning. I got nothing at 12:30 in the morning. I usually this one doesn't sound like it's going to need to be a 3-hour slot. So, but if you want to go ahead and I can set this for 2 hours on just in case, give it a whole 2 hours at 9:30 a.m. on February 27th or at 1:30 p.m. on May 27th. Or 1:30 p.m. on May 27th. Does that work? Either of those time frames work for you, Ms. Lopez?
Yeah, sure. No, I'm available all day.
All right, then. Well, I'll tell you what, let's go ahead and get this one done early. I'll go ahead and set it on we do special settings at 9:30, so I'll go ahead and set this up at 9:30, and I'll get the Zoom code out to the AG's office, and they'll get it over to you. And that's the only case we have at that time frame. And like I say, either I'll do it or Judge Law will do it. All right.
Okay. May we be excused?
Anything else, Mr. Welch?
No, Your Honor. But we'll work on this order later, not here at court.
Okay. All right. Anything else, Ms. Lopez?
No, Your Honor. I will, like I said, get the addresses hopefully over to the Attorney General later this afternoon, and that's it. Thank you.
All right. Thank y'all both very much. We'll see you when it's going to be a little warmer outside. Okay, on May 27th.
Thank you.
That should be right after Memorial Day weekend. So if I'm missing my guests, so anyway, everybody be safe. Have a great Easter, and we'll see you then. We're off the record.
Your Honor, the state's here requesting confirmation of the non-agreed order that was filed with the petition for confirmation. The parties in this case are agreed on conservatorship, current child support, current medical insurance, and current dental insurance. The bone of contention for these folks relates to retro amounts. They have done fantastic as far as co-parenting and child care is concerned. However, they have some disagreements or miscommunications or whatnot regarding the retro balances that are owed. So would just like to make the parties available to testify about the retroactive amounts, and that's really the only thing that's at issue here in this case.
All right then. All right, folks, you heard what the state's telling me. Let's see what the disagreements are about, what the math is. Of course, under Texas law, on a brand new paternity establishment case, the non-custodial party is entitled to have child support, retroactive child support, and that.
The judge then discussed the next steps required before the case could be completely resolved. Since Ms. Powers had not appeared in court, the legal system still needed to formally notify her about the case. Mr. Garcia's attorney explained that they had recently located an address where she might be living. She promised to provide that information to the Attorney General's office so the court could attempt official service. The judge explained that once she was served, she would be given time to respond to the case. Only after that step could the court finalize the new order. The attorneys asked the judge to schedule a future hearing to wrap up the matter once all parties had been notified. The judge agreed and began looking for an available date on the court calendar.
Go back up to 4 years. Obviously, this child's not even 3 yet, so we're not looking at going that far back. But I want to go ahead and get some information from the parties as far as what that financial information is. As I'll let the parties know up front, the court always gives any and all cash payments full credit. I look for major items. I give them full credit. If someone bought the child a new bedroom set or something along those lines, yeah, I'll look at that. Or made a car payment or something along those lines, I'll look at that. However, when we start dealing with items, that's when it gets hinky, folks, because a $25 box of Pampers at 7-Eleven is a lot different than a $25 box of Pampers at Costco. All right. So I'll see what you folks have been doing, see how y'all been handling, see what kind of agreements y'all had, and see what I can come up with as a fair and equitable ruling on what the retroactive child support should be at this point. But this time, I ask both of you to raise your right hands and let me get you under oath.
My left, sorry.
All right, you both solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth to help you.
Yes.
You're all officially under oath, and the state may proceed.
Your Honor, I'd like to call Miss Diaz Aguirre, please.
Now, state your
Yes.
full name for the record.
Angeles Diaz-Aguirre.
Good afternoon, Miss Diaz. I believe you and Mr. Hughes had a negotiation or discussion earlier this month regarding child support and all the related issues. Is that correct?
That is correct.
Were the two of you in agreement in regard to joint custody with the child?
Yes.
And were you also in agreement with the standard possession and custody order?
Yes.
And then you were also in agreement with the current child support obligation being $209. And then is it your testimony that you pay for dental insurance?
Yes.
And is that at $14 a month?
The dental currently is at $12.66.
$12.66. And then do you have a health insurance coverage for the child?
Yes.
And how much is that per month?
$95.15.
Okay. Now, in regard to the relationship between the two of you, have you ever received a child support payment on any regular basis from Mr. Hughes?
No.
And during the negotiation, did you discuss child support arrears for child support owed for back child support?
Yes.
Do you recall whether or not there was a balance alleged to be $12,626 for unpaid
Yes.
child support? Okay. Do you believe that number is fair and accurate as far as past due child support owed by Mr. Hughes?
Yes.
Okay. Did you also have a retro medical support claimed based on the fact that you had paid for health insurance premiums for the child?
Yes.
And is that also true that you paid for dental premiums for the child as well?
Yes.
And are you asking the court to award you the retroactive amounts that would be owed for the child support, the dental, and the medical?
Yes.
Other than that, are there any other disputes or concerns that you have regarding the entry of this proposed order?
No, sir.
No further questions for this witness, Judge.
All right, thank you very much. I'm ready to call Mr. Hughes. Here's the deal, Mr. Hughes. Again, this is kind of straightforward stuff. If you want me to do something different, you're going to have to explain to me legally how I can do something different. I know you're not a lawyer, but you are today. So I'm going to let the state call as a witness, and then at the end of this, I'm going to allow both of y'all to make a closing statement and closing argument if you wish to. But this time, I'll let you go ahead and answer the questions of the state. Thank you, sir.
Your Honor, I'd like to call Mr. Hughes.
Sir, state your full name for the record.
Juwan Hughes.
Good afternoon, Mr. Hughes. You'd heard at least a little bit of the testimony before. Were you a part or a party to a negotiation regarding the resolution of these child support issues a couple of months back or a couple of weeks ago?
Yes.
Okay. Do you recall during that negotiation the discussion of your current child support obligation being $209?
Yes.
Okay. Do you have any objection to that amount being Set? Okay. So is it fair to say then that the only real dispute, and I'll let you elaborate, but the only real dispute or concerns you have is to how the court would deal with any retroactive amounts that were owed, any back child support or dental or health? Is that the only issues that you need to deal with?
Yes.
Okay. I guess just to make it easy on you, Mr. Hughes, if you'd like to explain to the court, hopefully you've had an opportunity to kind of put your thoughts together. But I guess I can start with you, man, and just ask you, what's your position on the child support obligation and the determination of the arrears for child support? What do you have for anything you'd like to say to the court about the amount owed in back child support?
As far as the back amount, I know, like he explained earlier, that it's all kind of like speculative. So I'm kind of at a point of like, just go ahead and do it because it's all going to be speculative, and I'm already going to be at a wall making things meet. So it's more so of I don't want to go back and forth with anything. Like I've said to you and him, I don't have any problems with her. This is just where we are now, so I have to kind of like just deal with what comes with it. Um, so I mean, as far as the retroactive, do I think it's fair? Yes and no, because she does provide a lot more than I do, as far as the child and her finances, which I can't deny that, you know. Uh, but it's something that's going to be all speculative, and I just rather not go back and forth with her. I'd rather just work with her on this matter and do what we have to do. I mean, because that's just gonna be what's at the best interest of the child. Like now, do I think it's all the way fair? No, but I'm kind of at the point where I'm like, uh, I could get the help and get some kind of legal counsel for that, but what it's gonna cost versus what's gonna actually probably happen is here and there,
Yes.
and I rather.
It's an accounting thing, sir. You know, it's kind of like your income tax. You know, you plug in the form, you plug in the amounts, and it's there. And it's kind of hard to change that around, sir. The
Right,
only way I
correct.
can change it around is if you actually gave her cash money during that time frame and give you credit for it. That's pretty much it. Or like I said, bought something major. You
Yeah,
have
and
anything like
and I
that?
was under the understanding that like even if I was to do those cash things, it would have to be labeled a certain way, or when I do give it to her, or it would just be considered a gift because this is what happened.
Now we're talking about in the past, sir. I'm not talking about going forward. You've got to do it a certain way.
Oh yeah, I was speaking on in the past as well. Like I was told that in the last before we did the
Okay,
closure
still, sir.
dates.
I'll look at cash as not being gifts. Okay.
Oh, okay. All
If
right.
you got proof that you gave cash, then if you know Cash App or Zelle, anything like that, I can look at that. But I'll look at cash as being child support. You know,
Oh yeah, it was never any direct payment to her. It might have been just things that I bought, which
yeah, and see those are
that's the
gifts.
gifts. That's
Yeah.
the line of it, you know.
If you made up your mind what you're going to buy, cash, she gets to make up her mind what she wants to buy with
Right.
child.
Yeah. Right.
All right. Anything else, sir?
No, that would be it. I would, and I did talk to Mr. Coates about, I know in the agreement that it's Friday through Sunday. My working days are Tuesday through Saturday. So is there any way, if it can't be adjusted, I'll make it,
Are you
I'll have
talking
to,
about visitation?
yeah, for the first and third week.
Okay, no, sir, because yeah, he's 3 now, but he's gonna be 4 in school in a year or two, in 2 years. So it's always based on them having to go to school. So it's going to be based on that school schedule.
Okay.
Because by the time this comes back, I won't be the judge anymore. Because they look at these things every 3 years. I'll probably be retired by then, maybe. But by then he's definitely in school. So yeah, so everything's set up just like they're in
Okay.
school. Because sooner or later they're going to be in school for the next, hopefully, for the next 12 plus years. All right.
Hmm.
Yeah.
That's fine. Yeah. There's just a
And
question
you're
that I
not
had.
going to agree. As I said in my opening speech, folks, agree to stuff. Okay. You're a barber.
Yes, sir.
Okay, so yeah, your days are Saturday, so work with each other, change things around. Y'all can agree to anything because, like I said, believe me, nothing, the kids get sick, you get sick, or the kids get sick. Yeah, that's always fun. So work around the schedule. Y'all can agree to any schedule you want, but if you can't come to an agreement, you gotta go with what's in the order. All right, and don't let the new boyfriend and new girlfriend tell you what to do. All right,
There's none of that.
that's where half the problems begin. Believe me.
Yeah. Yeah.
Believe me, new girlfriends, new boyfriends paid for me a new Tahoe. All right, back in the day.
No worries there.
Yeah. Me either. So
Yeah. So back when I was practicing law, so it is what it is. Anyway, for anything else, sir?
no, that'll be it.
All right. Anything else, ma'am?
No, sir.
All right, Mr. Coach, I'm gonna go ahead and sign ask you I'll sign that order as is once presented by DocuSign. Again, sir, it's those are the circumstances. I'll go ahead and grant. I'm gonna name you both joint management server, get them on the right side of the domicile. I've said that for child support, cash, medical, and dental, as testified to, retroactive child support and repayment is requested, and obviously because I was wondering why it was so high, but that's because of the past dental and the past health insurance. So those are also under Texas law. They're there. It's rare that happens, but they're there. So I'm ordering repayment as requested in the court order, and I'll sign off on it. And I wish you both the best of luck, because again, he's 3 now, but believe me, like the old songs, like the old John Cougar Man Camp song says, he's young and he's improving. So y'all better watch out. All right. So
Thank you, Your Honor.
all right. Thank y'all both very much. Everybody have a happy Easter. Be safe out there. All right. Thank you.
I'll circulate an order to you guys once we get it back from the judge. Thank you.
Okay.
Off the record. Thank you, guys.
After reviewing the schedule, the judge set a final hearing for May 27th at 9:30 in the morning. He explained that the hearing would likely be short because most of the issues had already been resolved. The judge also made a lighthearted comment about his upcoming medical procedure and joked that another judge might handle the hearing if necessary. Before ending the session, he repeated that Mr. Garcia had been raising his daughter for more than 10 years and deserved to have the financial records corrected. The judge instructed the attorneys to prepare the necessary paperwork so the temporary orders could be signed. Once everything was complete, the court would return any held funds to Mr. Garcia and finalize the corrected child support order. The judge then thanked everyone for their cooperation and closed the hearing, wishing the participants well before the court went off the record.